Dear participants, my name is Pascal Pichona, and as president of the European Law Institute, it is my privilege and my great pleasure to welcome you all to this ELI webinar on the ELI principles on the use of digital assets as security. I will not present the ELI, of course, but do not hesitate to visit our website to discover all our projects or to apply to become a member. And you know, it's European Law Institute in one word.eu. Now, the ELI principles on the use of digital assets as security have been adopted very recently by the ELI. As such, they are certainly a significant and timely contribution to the legal discussion around digital assets and their various uses. Digital assets may indeed still amount to a very small share of most people's asset portfolios. Their popularity is, of course, on the rise. Digital assets cover a wide variety of assets, such as cryptocurrencies, stable coins, social media profiles, and online gaming accounts, NFTs, and so on and so forth. The recent published ELI principles seek to provide guidance on their use as security. This implies to set out key concepts relevant to the use of digital assets as security. In particular, the principles focus on situations where security providers secure the performance of their obligations vis-à-vis security takers by using digital assets as collateral under the terms of a security agreement. These principles also propose ways to identify the law applicable to the creation of security interests in digital assets and address issues of relevance to the effectiveness of security interests in digital assets against third parties, as well as the enforcement and extinction of security interests in digital assets. These principles may therefore provide a source of inspiration and guidance for the further development of case law, legislation, and of course, soft law instruments, as we will hear tonight. Further projects by Unidroid, UNCITRAL, or the HCCH have been launched or will also soon come to an end. It is therefore of great relevance to have tonight on this webinar also experts from other projects to react or present their views in order to better understand the specificities of the ELI principles. But I do not want to enter into more detail myself, given that we have tonight an outstanding panel of reporters, speakers, and experts in this field. They will each speak for about 15 minutes, some a bit more, and then we will have a Q&A session of about 25 minutes. Let me already thank the panelists for giving us the honor and the pleasure of being with us tonight. I'm truly looking forward to their presentations and to the various paths that their reflections and of course the ELI principles will open. Now, before listening to them, let me give you some technical instructions, if I may say so. Q&A function is available to put your questions, and use this opportunity to ask questions to the panel already while or during their talk, so that you may increase your chances to have your question picked up at the end, and maybe also generate other questions by other people attending this webinar. We will begin with a presentation by one of the ELI co-drafters of these principles, and then we will go on with the other panelists. So let me first present you Phoebus Athanasiou. He is the co-drafter of these ELI principles. Phoebus Athanasiou has a PhD in law from King's College London. He's a senior lead legal counsel at the European Central Bank and an associate professor at the Institute of Law and Finance of the Goethe University. Has published extensively on financial services, law and regulation. I just want to mention two recent monographs, one on digital innovation in financial services of 2018, and the most recent one, the European sovereign debt crisis, breaking the vicious circle between sovereigns and banks, that he published in 2021. I'm really thrilled to listen to you, Phoebus, to see what the co-reporter of the ELI principles has to say, and therefore you have the floor.
Thank you very much. Can I ask if you can hear me?
Yes, very clearly. Thank you.
Very good. So, Mr. President, thank you very much, and many thanks also to those of you who are attending today's webinar. What I'll try to do is to walk you briefly through the work of our group on the report and discuss with you some of its salient points. Now, the task that we were given was to prepare a report on the use of digital assets as security in a commercial setting. You will be aware that the legal characterization of movable assets, tangibles and intangibles alike, the types of security interest in them, the requirements for their creation, and the conditions for their effectiveness against third parties vary greatly across different European jurisdictions. At present, the European Union lacks a common framework for secure transactions comparable to what the Uniform Commercial Code provides in the US, and I would imagine that it's unlikely to have such a common framework in the foreseeable future. So we took a practical and pragmatic approach to our task, and in our work we placed the emphasis on 3 points. First, defining the concept of digital assets that we would work with. Second, circumscribing the type of assets we access, not assets, but access that we aimed for in our work. And third, striking a balance between substantive and conflict of law rules. Now, starting with the definition of digital assets, which of course is central to the principles we've produced, you will be aware that this is a concept that is notoriously difficult to pin down. And this explains also the multitude of competing definitions and the substantial differences in their emphasis and their scope. So rather than proposing in the report an exhaustive list of qualifying digital assets, what we did was to try to identify the core characteristics of a digital asset if this is to be suitable for use as collateral. And what we agreed is that a qualifying digital asset must of course be intangible. It should embody measurable value, which is to be understood in economic terms primarily. It should be capable of being the object of control by an identifiable party. And finally, it should be amenable to a transfer by way of assignment or otherwise from one party to another. Now, the types of assets that fulfill those characteristics include social media and other online accounts, provided that measurable value attaches to them and provided that no legal obstacle stands in the way of their assignment. They also include, obviously, cryptocurrencies and stablecoins. They include uncertificated financial assets, meaning those that only exist electronically in the form of tokens, such as, for instance, security tokens. They also include non-financial asset type tokens, such as utility and certain payment tokens. And finally, they include also hybrid tokens. Our proposed definition in the report is technology neutral. It is agnostic in terms of the legal characterization of a digital asset, whether, in other words, this embodies a proprietary right or instead a claim. And it captures both pure digital assets, in other words, those created and existing in the digital world only, and digital representations of already existing real world assets. Cryptocurrencies and stablecoins are an illustration of a genuine digital asset, since they are created and they only exist in the digital world, whereas, for example, security tokens can be examples of digital representations, as they are mere reflections of existing real-world assets. The concrete examples of digital assets that we cite in the report are all rivalrous in nature, and their design features are consistent with the creation of a security interest in them, as well as with the enforcement of such an interest by secured creditors. Now, I turn briefly to the question of access. And here again, we refrain from proposing a legal definition of the term access. What we did instead was to focus on a particular type of access, which is the use of a digital asset as security for lending. Now, other types of uses are possible, but these other types of uses were not considered in our report. What are those other types of uses? They could include succession to digital assets, and they could include the seizure of digital assets by order of a court. Now, the common thread that runs through these forms of access is their shared emphasis on the economic use of digital assets as repositories of value that can be monetized. And it's precisely this value that the principles seek to unlock. Now, in terms of substantive rules, the report is admittedly quite modest. Principle 2, sub-principle 1, conditions the use of a digital asset as security on the conclusion of a security agreement between a security provider and a secured creditor. Principle 2, sub-principle 2, states that the use of digital assets as security is subject to compliance with the provisions of the law governing the creation of security interests as per principle 3, and to the law governing the effectiveness of security interests against third parties as per principle 4. Now, the remark I just made begs the question of the balance that the report strikes between substantive and conflict of law rules. Acknowledging the difficulties of a substantive law harmonization, we have refrained from developing in our report the equivalent of a substantive model law on the use of digital assets as security. Instead, we've placed the emphasis on identifying the conflict of laws rules governing the creation of a security interest and its third-party effectiveness. Although many national legal orders will not regulate the question of the use of digital assets as collateral, it was our conviction that national legal systems are perfectly capable of dealing with the challenges posed by the use of digital assets as security, provided some guidance is at hand to help those dealing with digital assets as security to determine which substantive law applies to them in a cross-border use scenario and how this is to be applied by analogy to the case of more conventional assets. And it's precisely this sort of guidance that we aimed to provide in the principles. Now, as regards the conflict of laws rules that we propose in the report, our starting position had been that the parties to what are effectively private contractual agreements regarding the use of digital assets as security should be free to decide which legal regime will regulate the use of those digital assets as security. However, as our thinking around the question matured, we formulated a handful of conflict of law rules consistent with the features of different types of digital assets and with the choice of law that those features were mostly conducive to. Our default position, both for the creation of security interests in digital assets and for their third-party effectiveness, is that the applicable law is that of the security provider's place of business or central administration or habitual residence. And that default position is consistent with the conflict of law rules on security rights in intangible assets in the UNCITRAL model law on secure transactions. And it is also consistent with the approach followed by the European Commission in its proposal for a regulation on the law applicable to the third-party effects of assignments of claims. There, the Commission proposed the law of the assignor's habitual residence as the law applicable to the third-party effects of assignments of claims. Now, again, this is only our default position, with the principles proposing dedicated conflict of law rules applying to different types of digital assets. And indeed, in some cases, the choice of law rules we propose will point, for example, to the law of the digital asset itself, rather than to the law of the jurisdiction of the security provider. So these are, in a nutshell, the reasons why the most substantive share of our work is devoted to choice of law rather than to substantive law provisions. Now, we've tried to include in our report illustrations to help the reader appreciate the practical application of some of the report's provisions, and hope that those who will read the principles will find them indeed helpful in illustrating the points that we make in the principles. Now, to conclude, I would say that our work on the report took a considerable amount of our time. It required a great deal of investment in research and most of all in reflection. We benefited greatly from discussions with the former ELI president and current ELI scientific director, Christiane Wendehorst. And I believe to be speaking also on behalf of my co-authors in extending our gratitude to her for devoting so much of her time to our work. The ELI president, Professor Pichonaz, has also been very helpful, and we would be remiss for not thanking him for his help. As always, the quality of the result is for the academic community to assess, and no presentation that I or anyone else might give today or on a future occasion can be a substitute for the actual study and evaluation of the report. So with these remarks, I would thank you all very much for your attention. I look forward to our discussion later today, and in particular to your feedback on the principles. Thank you.
Thank you very much, Phoebus Athanasiou, for this very clear presentation of the content, but also on the aim of the co-reporters or co-drafters of these principles. I think that was very useful and very clear. And thank you also for your kind words. I have now the pleasure to pass the words to Matthias, Matthias Lehmann. Professor Matthias Lehmann is professor of private law, private international law, and comparative law at the University of Vienna. And he will be on the panel today because he's one of the assessors of the ELI project on access to digital asset. And so in that position also, he had to work intensely with the project that was provided to him so that he could reflect, and therefore we look forward to it. I wanted also to mention that Matthias Lehmann teaches also in foreign universities like the Sorbonne University in Paris. So he hesitated to speak in French today. He has spent also some time at the University of Fribourg or the University Pablo de Olavide in Sevilla, Spain. So probably he speaks all these languages. And therefore, when it goes to applicable law and conflict of law, he will have no difficulties at all to look at the given legal system. So we are thrilled really to listen to you. And Matthias, I give you the floor.
Thanks very much, Pascal, for the kind introduction. I am very pleased to speak on these fascinating principles. They are really fascinating in the sense that they address a problem that is very current and also extremely difficult to decide. I must say it's in the conflict of laws, one of the most intricate problems that I've ever met. And what has been presented to us are very, very helpful principles, I would say, that cannot be found anywhere in the world. So legislators around the world just grapple with these questions. So it's extremely timely to have those principles at hand, and it may be very valuable for legislators, not only inside the European Union, but also outside of the European Union to use the knowledge that went into this. And I most think of these principles. We talk about security interests and secure transactions. in classic terms, as we know, collateral that is provided for a credit and so on. But I think in the digital world, these principles may be of use also in very novel contexts. So to give you one example, in the DeFi world, in the world of decentralized finance, we have new arrangements that allow people to earn some interest on their crypto assets. It's called staking, or depending on the network that you do it, it's also called baking or yield farming, or crypto lending. And in many of these transactions, we see that one party delivers or gives control over its assets in return for either getting something, some currency, or for getting some yield at the end. And it's not always sure how to legally characterize those, but it's, in my view, not completely excluded to characterize some of these transactions, at least, as secure transactions, because actually what you do is you give up control over your digital assets for a certain time, and then you regain control. So could be extremely wide, the application. Where I was rather surprised is the application to social media accounts. That's not something that I had particularly on the radar. It's a little bit unusual in the sense that normally we think about assets that are highly transferable. Social media accounts, not necessarily true. I agree that they are of high value, but I always see them a little bit different from the other digital assets. But we can, of course, discuss that. The principles opt for the general rule of applying the law of the security provider. So the law at the principal place of business, or the habitual residence of the collateral provider or security provider. And this is, of course, you can buttress this as Freebus has done with the ancestral model law on secure transactions. Also, as you have rightly mentioned, the proposal of the EU for assignment, also the ancestral convention on the assignment of receivables. So in all of these texts, we see that this is used as a connecting factor. So I don't want to dispute that, and that this may be a helpful connecting factor. Some have criticized this and have said, well, you know, the domicile or principal place of business is not necessarily transparent in a blockchain environment, for instance. But I think this criticism would be correct if we talked about ordinary transfers. If we have secure transactions, there is usually some kind of agreement between the parties that evolves around that. And usually they know each other, because you give security because you get something in return, you get a loan or something. So in order to get that loan, you must be in contact with the other party, and you will certainly also know about the other party. So I don't think that the criticism of pseudonymity on the blockchain would really be valid in the context of secure transactions. Then there is always the criticism that the domicile or principal place of business can change. Well, that's true, but so can other factors. So I don't think either that this criticism is valid. Where I would be more interested in is if we had two conflicting secure transactions. So A does not double spend the same digital asset, but double secures or use it in two different secure transactions with two creditors. If we now apply the rule, we would say, well, the law under which the secure transaction is perfected, is finished, or is actually executed, that's the one that produces the valid security interest. But the difficulty is that that must not necessarily be the first law or the first transaction, right? Under which the security interest is supposedly created. We could imagine that we have a first transaction A by a security provider under a law where there are additional requirements that are not yet fulfilled. And then he enters into a second secure transaction where the conditions are immediately met. And then the question for me is, which is the secure transaction that has priority in this conflict of secure transactions? Is it the first one because it's in the time order, the first one? Or is it the second one because it's legally becomes binding before the first? Maybe we can discuss this case. The principles then make an exception in principle 4, paragraph 3, that says, well, we derogate from principle 4.2 about the place of business, central administration, or habitual residence when the digital asset itself is clearly connected with one particular jurisdiction. Now, as it always is with exceptions, the exceptions may prove to be more important than the rule. And in the explanations, we find a number of cases when there may be such a close connection, and I find them most interesting. So one case that is mentioned is, and I think rightly so, is that of a permissioned blockchain. If we have a permissioned blockchain, then it is, well, this is usually the case that we have a central operator, an operating authority that admits, that gives these permissions for some nodes to join the network or to validate transfers on the network. And when we have such a central operator, then one could argue that there is a close connection of the whole blockchain, of the whole system, to the country of this operating authority. And I would strongly agree with that. And that would then supersede, in a sense, the connecting factor of the law of the collateral provider. It would be not the law of the collateral provider, but the law of the system that governs. The same thing could happen if we had a custodian that would have the digital assets in custody. We could argue that then in this case we have a stronger connection to the custodian, and the custodian's law applies. And one could even say, if we have such, and that is the most interesting case, I think, if we had a chain where in the chain itself there is a choice of law, maybe coded into the source code of the blockchain, then this choice of law would apply to all transfers on the network, including those that are for collateral purposes. So that means we have a number of exceptions, right? And it would maybe even helpful to spell them out and make them more explicit, that prevail over the connecting factor of the principal place of business or habitual residence of the collateral provider. When discussing this at Unidroid, in the digital assets working group, we were actually turning it around and started with the exceptions and then came down to a default rule, but that's a matter of style, I think. Okay, do I still have some time? Yes, I have some time, I think. The asset-backed coins, that is another very strong point of the paper, of the principles on which they elaborate, and I think very correctly. So the point here is, if we have coins that are backed up by real world assets, then we actually need to follow two conflict of laws rules. We need to follow one conflict of law rule for the coin on the chain. We need to identify the law applicable to the coin, to the digital asset, right? And a separate one for the real world asset that is represented. Now, there can also be, of course, digital assets that are represented by digital assets, or let's say virtual assets that are represented by digital assets. Just think of a shareholding, a share or a bond, which is in a sense not really real world, because most are today dematerialized, but could be thought of as a non-tangible legal object that is represented by a coin, and they could still be governed by two different laws. The coin may be by the law of the blockchain or of the custodian, whereas the share, for instance, must certainly be governed by the law that applies to the company. But be that as it may, I think the distinction is clear and has been made between the law that applies to the coin and to the law that applies to the real world asset. And then it's said that, well, helpfully, I think, that when that's under 3.5, if the applicable law to the digital asset to the real world asset makes the creation of the security interest conditional on the physical delivery, then that condition is deemed to be fulfilled if you transfer basically the digital asset, which I think is an extremely helpful point. But I would criticize the last half sentence, even if short of the actual physical delivery of the digital asset to the secured creditor. I think it must be here, even short of the actual physical delivery of the real world asset, because the digital asset can never be physically delivered anyway, right? So I think the principle nevertheless is extremely helpful, because it tells us that the delivery of the digital asset can have some effect on the transfer or creation of a security interest in the real world asset. So most helpful. Finally, I'm getting to my last point, that is related again to principle 4. So I'm jumping a little bit back and forth, sorry for that, but I wanted to address those asset-backed, as I call them, asset-backed digital coins or digital assets. Most representative of them are of course stable coins, right? But it's only one case. You can also back up with assets without having a stable coin feature. Principle 4 deals with the effectiveness, or as the Americans would say, with perfection, right, of the security interest. And it says that you must meet the requirements of effectiveness under the law that is applicable to the digital asset, as we have defined it before. And it also gives some indication of the timing, of course, because it's at the time of the creation of the security interest that this criterion of the either principal place of business or habitual residence must be fulfilled. We have the same exception in 4.3 for the clearer connection. Then we have a principle again on real world assets. Then 4.5 deals with systems that have transaction filing or notice filing systems for creation of security interests. Some legal systems have those specific systems, and it's said there that it is sufficient that you comply with the system, so that you file a notice in the system that you are now that you have a security right. And finally, and that's the one that I'm most interested in, 4.6 says that if you have none of these, then the security interest becomes effective against a third party once the secured creditor has gained effective control of the digital asset. So what I find interesting about this is 4.1 gives the impression, and I think that's meant seriously, that is the applicable law that is going to decide when the security interest is created. So it's a pure conflict of laws principle that just says, look at the applicable law, okay? But then we have in 4.5 and 4.6, we have substantive rules that says, well, if this applicable law has these and these requirements, then they're deemed to be fulfilled. I guess that is done because this issue of secure transactions in digital assets is so new that many legal systems haven't yet specific rules for them, right? And the same is true for 4.6, which says, in principle, the law of the habitual residence or of the principal place of business tells us when perfection or when effectiveness against third parties is achieved, but we have a substantive requirement that is control. The secured creditor must obtain control. And that is a very interesting approach to it, which basically the French would call it une règle matérielle de droit international privé, a substantive rule of private international law. Although we leave it to the applicable law to determine the conditions for effectiveness against third parties or perfection, we tell the user that there must be always this condition of control that must be met. Otherwise, we cannot speak of a valid security right on the blockchain. And I think that is extremely helpful and correct, because in this environment where basically the whole world meets, people from many jurisdictions meet, and potentially many different laws can be applicable. Just think about how many people are worldwide on the blockchain and who may engage in staking, yield farming, or other kinds of secure transactions. It is extremely hard to foresee what kind of conditions a national law poses for the creation of a security interest. And therefore, it's helpful to give at least one yardstick and tell users, well, whatever the applicable law says, at least it must provide for a minimum of transfer of control or gaining of control by the creditor. Otherwise, there can be no security interest. And I think that is absolutely correct. It's a little bit unusual from a conflict of laws perspective to mix substantive law and conflict of laws rules, but I think this is justified by the global nature of this network. And that means, of course, that the notion of control is extremely important, which you have helpfully defined. So control, I think, is a key term in this whole thing, and we cannot just leave it out and say, well, if some legal applicable system doesn't require control, that's fine as well. No, it's not fine. Either they have a filing system or there must be control, because control substitutes for the transfer of possession in the real world. I think we cannot avoid this kind of rule, and I'm very grateful for it being there. Thank you very much.
Thank you very much, Matthias. Thank you very much to Professor Matthias Lehmann for these very insightful comments and reflections. And I see already a whole bunch of questions that will be discussed later on, but we have also some questions already in the Q&A. And again, feel free to add questions to this Q&A. We will have some time left for these at the end. But right now, we will have the pleasure to listen to Professor Louise Gallifer. She is a QC, FBA, and also Rouse Bowl Professor of English Law at the University of Cambridge, and a Fellow of Grenville and Caius College at Cambridge. always very important when you speak about English people to show to which college they are linked to. She teaches and writes, of course, extensively in all areas of commercial and financial law, as you know, and she has seminal books. So I won't go into all the books that are published by Louise Gallifer. And she's currently co-director of a project on digital assets based at the Commercial Law Center, Harris Manchester College, Oxford, and chairs also the drafting group of the Unidroid working group on the private law relating to digital assets. So, dear Louise, it is always a pleasure to listen to you. So please, you have now the floor, and I'm thrilled.
Thank you very much indeed. Thank you for the warm welcome, and lovely to see everyone, and also to be able to look at this project, this ELI project, in more detail than I've been able to do before, and to think a bit more about how it relates to what we've been doing at Unidroid. So the Unidroid project is, perhaps I could have the next slide actually. Thank you. What I tried to do here was sort of give some very high level similarities and differences between our Unidroid project and the ELI project. And one thing I didn't put on here, but has been a little bit apparent to me listening to what, especially what Phoebus has been saying, is that there is one difference that is a sort of rather major difference, I suppose, in that the ELI project is, at least in the first instance, focused on EU law, or law within Europe, whereas Unidroid basically is operating for the entire world. Now, Matthias said, probably rightly, that the ELI project will also be an inspiration to law reform around the world, but that is certainly one of the remit of the Unidroid project. Now, the similarities are pretty obvious. I mean, firstly, both projects focus on private law as opposed to regulation. And we at Unidroid take that very seriously. So although our project is more substantive, more to do with substantive law than that of the European Law Institute, it's very much focused on private law, rights between parties. Second, we try to be technological, and legal culture neutral. We're all trying to do that all the time. Certainly the technological neutrality is very challenging, but we are both, I think, trying to do that. This is the softest of soft law. We're talking about principles, not rules. And I'm not sure how everyone in the Unidroid project would say they see it. I'm not sure we all exactly see eye to eye, but from my common law viewpoint, at any rate, I see the Unidroid project as, in a sense, a kind of checklist. In other words, saying, look at your own law and see whether these principles are already there. And if they're already there, you don't need to do anything. And if they're not already there, we suggest that you do something about reforming your law. So it is not, in that sense, seen as a complete code. And it isn't a complete code anyway. But on the other hand, I think we would both say that our projects are setting international standards, and so are setting standards which could be used by a state to decide what their law should be if their law doesn't already have these types of standards in it. And as has been said by our other speakers, this is a very new area. So there are many jurisdictions that haven't thought specifically about what their law should be in this particular area to do with these types of assets. Now, both of our projects defer many issues to national law, perhaps in slightly different ways. As been said, the ELI project tends to focus on conflict of law rules. You'll see the Unidroid project is more of a substantive law project, if you like, but it has very clear boundaries, and many issues are not dealt with in the Unidroid project, and I'll explain that in a minute. The two main sort of scope differences, I suppose, are all to do with the focus of the project. So the ELI project is obviously about taking security over digital assets. Now, the Unidroid project is not just about taking security, although this is covered in some parts of the project. It covers outright transfers, it covers custody, and some other matters. So enforcement of claims and so on. And so it is really more looking at what we might say is the whole of property law. But as you'll see in a minute, it doesn't in any way purport to be a code for the whole of property law. It only focuses on certain aspects. And that's the second point on the slide, that while the ELI does try and cover all aspects of taking security, it looks at creation, it looks at perfection, if we can call it that, priority to some extent, and enforcement, the Unidroid project only provides substantive principles where it's considered necessary because of the special features of digital assets. So it hasn't sort of gone through point by point. It just says these are the areas where we think we actually need substantive principles, or as I call them on the next slide, substantive rules. So they're not really rules. Perhaps we could have the next slide, please. Okay, so this is a version of something I created actually for the project. And I put rules in inverted commas because, as I said, these are principles and not rules, but these are, as it were, the propositions of substantive law that come out of the Unidroid principles. And so the principles have these various propositions of substantive law, and then there is analysis that, as it were, supports those propositions of substantive law. Now, I haven't included all the propositions of substantive law, partly in interest of time and partly because I couldn't fit them on the slide, and partly because we haven't finished them. In other words, I haven't included the principles on custody because I don't think it's relevant to what we're talking about here, at least not in the timescale we've got. And I haven't put anything on enforcement because we are still working on those, because there is actually a Unidroid project on enforcement. And so we're still working on the enforcement principles for digital assets to fit within that project. But I wanted to show the architecture in this way because I think it explains some of the main differences between the Unidroid principles and the ELI principles. Because those differences can to some extent be explained because of the difference in architecture and because of the way that we've approached in the Unidroid, we've approached the issue. I'm going to focus on three specific points. There are other things perhaps I could say, but three specific areas which will sort of draw this out, hopefully. Firstly, the definition of control. Secondly, the relationship of the Unidroid principles with other law, as we call it. And third, the conflict of laws rules, because we do include a conflict of laws rules, but some of our principles are effectively substantive, as Matthias was saying, but there are more of them, I suppose, because we're wider. Okay, so let's start with control. Now, in our Unidroid principles, we define control, we don't use this word, but it is effectively factual control. It's not legal control. It looks at whether the person in control, or purportedly in control, has exclusive abilities to do certain things, such as change control and prevent somebody else from changing control. And we've deliberately done that. We've not looked at what I would call legal control, whereas at least in the definition, the ELI project defines control as legal power or factual capability. And the legal control in the commentary is said to be the security provider's exercise of a legal right to control that digital asset. Now, I have to say, I don't know exactly what that means. It's not quite what I would mean by legal control in the way I tend to use it in other contexts. I would say that a secured creditor has legal control where someone in factual control agrees with the secured creditor, either that the asset cannot be disposed of without the secured creditor's consent, or that the secured creditor can give instructions for disposal without the security provider's consent. But in either case, the secured creditor has no factual power to achieve these things. In other words, has no factual control. Now, of course, the person in factual control will often have legal control, however it is defined. The two often go together, and if they go together, then I think we sort of go along in the same path between our two sets of principles. The difference, if there is such, is that at Unidroid we focus entirely on factual control, and we do this because control has a number of different purposes in the Unidroid principles. I mean, if you look at the slide, you will see that the definition of control turns up as the supporting analysis for pretty much all the propositions of substantive law that I put on the slide. And therefore it does various things. And because of that, we feel we've got to have a purely factual concept. So first of all, control sets the boundaries for what a digital asset is in our principles. So in the Unidroid principles, a digital asset is defined as an electronic record which is capable of being subject to control. Now, I see that in the ELI principles, you define control as one that is subject to a right of control, enjoyment, or use. And I wonder whether that is wider than merely saying it's an electronic record that is capable of being subject to control. And if it is, you have a wider definition than ours. Because for us, it's not just about drawing the boundaries of the project, but because control is so central to the substantive rules, it wouldn't make any sense if the digital asset was not capable of being subject to control. And it's also central to our first substantive rule, which is that digital assets can be the subject of proprietary and security rights. We decided it was the fact that a digital asset could be controlled by factual control that meant it could be subject to a proprietary right. Now, our one of our substantive principles is the innocent acquisition rule, which is that an innocent acquirer takes free of conflicted claims, and that is bounded by control. To be an innocent acquirer, a transferee must obtain control of a digital asset, again, factual control. And the other, perhaps main substantive rule is the one that Matthias Lehmann has just been talking about, which is very similar in our principles, which is that a security right in a digital asset can be made effective against third parties by control. And the effect of the Unidroid principles would be that we would suggest that should be an international standard and should be part of domestic law. We also add that where that happens, a security right that is made effective by control has priority over a security right made effective by other means. Now, all these rules are predicated on control being factual for various reasons in the security context, which I suspect that the ELI would agree with. One is it leads to some form of publicity. It's not perfect, but it's better than private control in a private agreement, private legal control that could be hidden in a private agreement. Factual control gives the secured creditor more ability to protect itself from grant and misuse, enables enforcement to be more easily effected, and amounts as well to the innocent acquirer or the secured creditor, both those rules, having done everything they could do to get the digital asset. And we do take the view that control should be made available as a means of making a security right enforceable against third parties, irrespective of whether a state has a registration system, and there perhaps our principles do diverge. So, very briefly, other law. We basically have our substantive rules, which you can see on the screen, and then we say everything else is dealt with by other law. So we think there is an awful lot of other law out there. This is private law to do with all sorts of things, to do with contracts, to do with whether somebody who effects a change of control is authorized to do that, and so on. So where a person, so for example, if we take the innocent acquirer rule, where a person who acquires a digital asset that doesn't fall within the category of innocent acquirer, whether that person obtains a proprietary right and how strong that right is a matter for other law. The other thing that is a matter for other law, and I'm happy to expand on this in the Q&A, but I want to get on to conflict of laws before I run out of time, is where we have what we call a linked asset. And I think we probably see eye to eye as to what we mean by a digital asset linked to an external asset. But certainly for us, an external asset can be anything tangible or intangible, which would include a debt security, an equity security, a contractual right, and so on. As Matthias was saying, where not just tangible assets, but where a token purports to be linked to another asset, we say that is all a matter for other law, whether there is a link in the first place and what the effect of that link is. Just coming on to conflict of laws. So we have, we've developed a conflict of law, but the conflict of law rule is within our principles for identifying the applicable law for proprietary issues that are covered by our own principles. Although it's expected that a state or tribunal using this rule might extend its application beyond that of the principles. And I think, as Matthias has suggested, it is formulated a bit differently from the ELI principles. So if I could have the next slide, please. It is a waterfall. We call it a waterfall, and it's sort of the other way up, if you like, from the ELI waterfall. So we say that, and this applies to all the principles, not just secure transactions, which may be another reason for the way we've adopted this. First of all, the law specified in the asset. And we mean by that specification actually in the metadata of the asset itself, or in records attached to or associated with that asset if such records are readily available for review by persons dealing with that asset. If there's not a law specified in the asset, we look to the law specified in the system or platform. And so we're not just looking at a connection, this is actually a specification where it's easily, or at least readily available for other people to look at. So it's a sort of objective test, if you like. And then the third, and as it were, the bottom of the waterfall, which is pretty radical, if you like, is that we suggest that a court, if 1 and 2 don't apply the Unidroid principles, and to the extent that issues are not dealt with in those principles, which is quite extensive, then they apply the law applicable by virtue of the rules of the private international law of the forum. We have chosen these way of doing it because we feel that the usual connecting factors based on location don't really work according to digital assets, whereas it would work if there was a clear indication of a law that related to that particular asset. It would be easy to find that out. We also think the first 2 steps would provide an incentive for those who create new digital assets or govern existing systems to specify the applicable law. And then the bottom of the waterfall, we think that this would not only encourage fora to apply what we would suggest are substantive principles that we think should be there, but also allow national law to apply for issues we don't deal with. So to just give you an example, if the issue was whether a security right was made effective against third parties by registration, then that issue is not dealt with in the principles, and the applicable law would depend on the private international law rules of the forum, which would probably apply the location of the grantor. In other words, the same as the ELI default rule. On the other hand, if the question was whether the security right was made effective against third parties by control, and we would say, well, the principles would apply to define what by factual control what is meant by control. So the principles apply where they apply. Otherwise, you look to the law that the forum would choose. And so I think it is probably true that even on choice of law, we are not that far from the ELI principles, but to the extent that we don't have the same formulation, it may well be that that's because our conflict of law rule is not just about security rights, it's wider in that sense. But of course, it's narrower in the sense that it only applies to, in theory at least, the rules that come in the principles, and it only applies to proprietary and not contractual issues. So we don't really say anything much about the creation of security interests or the validity of a security agreement. That would be a matter for national law, which wouldn't be covered by, at least by the principles. And I think, I'm looking at the timing, I think I ought to stop there. Pascal's nodding, so I'm sure we'll have more chance to discuss it in a minute. Thank you.
Thank you very much to Louise Galliffer for this very interesting comparison between the work done by Unidroid and the ELI principles. So it helps also, of course, by looking at the differences to understand better the ELI principles. And of course, once the Unidroid principles will be available in full to look at them also more closely. I realize that we have a number of questions in the Q&A and also some that come out from your respective presentations. And one aspect that seems to I mean, we have several aspects, but one aspect is, of course, the issue of control. And here, Louise Galliffer made a point to say there's quite a huge difference between, or an important difference between the Unidroid and the ELI principles as a matter of control. And there's a question also by Anna Plevry, saying that, of course, the issue of control is crucial, and getting into how we have control also in terms of civil enforcement of the digital asset. So I don't want to come to enforcement immediately, but there was also a consideration whether we would need to use the issue of control, and that's Manuel Alba, when maybe in a digital world the issue might be different. So maybe Phoebus, you might begin to reflect on that, and maybe either Luis or Matthias could add something afterwards.
Yeah. Well, I could talk for hours now on this particular issue, because I mean, I wouldn't want to, because it would mean replaying lengthy discussions that we had in the process of drafting the principles. Now, sometimes the perception of the reader is conditioned by the choice of words, because on the substance of the matter, I think that also we are perfectly happy with factual control only, without in any manner or form requiring that the concept of control has a legal content to it. Now, it was said earlier also by Luis that in many cases the two will coincide, and that's of course something that adds to the complexity of dissecting what exactly one means by the concept of control. But what I would say is that we can be perceived perhaps as being more liberal than Unidroit in accommodating also the option of legal control as the type of control that satisfies us for the application of the principles, but factual control is very much a component of our thinking, and we also state this explicitly in the report. Factual control is crucial when it comes to protecting the interest of bona fide credit providers who may not have the means to establish, especially in the context of these nebulous digital assets, they may not have the means to establish the title, the good title of the security provider over a digital asset. So yes, the concept of control is important. Yes, our choice of words may suggest that we require a confluence of legal and factual control, but I think on a second or perhaps a third reading, it's clear that we are perfectly happy with factual control, which will many cases be the only type of control conceivable in this particular context.
Thank you very much, Phoebus, for these aspects. Matthias, do you want to add something on that point? No, not necessarily, but I saw that you. Oh.
I think. Can you? Oh, you hear me now?
Yeah, now yes.
Okay,
yes.
sorry. Internet connection was unstable. So I just wanted to add, maybe the difference is not so big. We would have to study this more carefully, because I think at Unidroit, the emphasis is on factual control. That's absolutely correct. And Luis has correctly spelled that out. And we need that already for the definition of the digital asset. Something that is not under control cannot be a digital asset. I think there's no disagreement with the ELI there. But then again, Unidroit also says that when a custodian has factual control over an asset, you can obtain, if I'm not completely mistaken, you can obtain a right in this digital asset by an agreement, a control agreement, or however you want to call it, with the custodian, isn't it? So if the custodian agrees that he exercises control for his factual control for a new acquirer, may it be somebody who acquires full title or who acquires a security interest, I think, but Luis has to control me here on that and tell us whether I'm correct. But I understand that there can be such agreements that with a custodian that then allow us to transfer rights or to create security rights, and that would be very much the kind of legal control that that the ELI principles talk about. So it's probably just a matter of drafting, I guess.
Can I just come in?
Yes, sure. Yep.
Well, kind of. It depends. If we're talking about making a security right enforceable against third parties, which is all we're talking about at the moment, I think, then what we've said is that either the secure creditor has to obtain control, as in factual control, or a custodian has to hold the security, has to hold the digital asset for the secure creditor. So it wouldn't be enough to have the custodian holding the digital asset for the client and have some kind of side agreement that had nothing to do with the custodian client agreement, and it had nothing to do with a change in control of the digital asset in a factual way, which just had some kind of agreement that the custodian would, in some circumstances, do what the secure creditor told them to do. Which sometimes could be a control agreement. And we haven't gone down that route, although in some jurisdictions that's a way of getting control over other assets. And that's, I mean, we're still discussing this, and you know, we might change our mind, I suppose, but it does seem to me that if we're going to go down that route, we'd have to call it something different rather than call it control, because we very much wanted to keep this idea of factual control. I mean, the word control has been used in so many different contexts in so many different jurisdictions that I think it's, you know, if we could think of a different one, we would, but we can't. So we've tried to stick with factual control. But could I just say something about the Manuel Alba's point?
Yes, please. Yeah, because I wanted to get back to that.
It's a really interesting idea. I mean, the idea, as I understand it, and no doubt tell me in the chat if I'm wrong, or you know, is that it's saying, well, why do you need to have control if you don't want to, if you want to make an alternative to registration? Why couldn't you just have a notation on the digital asset itself? Why, you know, why couldn't you basically? I think what is being suggested is use the metadata of the digital asset as a kind of register or something like that. And I mean, we haven't really thought about this, so I can't, I'm only giving you off top of my head view, but I think that there are probably several reasons for this. I mean, one is that it will be an entirely unregulated register in the sense that, you know, I don't even know who can change the data. I mean, if you know, on a digital asset, but if you set up a digital asset so that anyone could just change the data on it, any secured creditor, you would then get a situation where anyone could change it and it could be actually completely false and not represent the real world at all. You have no way of treating it like a kind of register where you'd have a registrar who could take off false registrations, and it could be a kind of free for all. So that's one thought on that. I mean, I think the other is that my understanding, and this isn't English law, so I'm really, you know, talking about other jurisdictions now, that the idea, and to some extent, I think this is the European Financial Collateral Directive idea of control, is it is more than just a publicity device. It is also enabling the secured creditor to improve its position by being able to enforce easily. And that, in that sense, it's like possession. If I have possession of your bicycle, which you've given to me as a pledge, and you don't pay, I just take the bicycle. I got it. I don't have to go and take it from you. Sorry, we always use bicycles as the example in Oxford and Cambridge because we have a lot of them. And so, you know, you can enforce very easily if you have possession. And so I think the control is seen as an equivalent of that as well. So it's like, I hope you won't mind me saying so, but Guy Morton, when I used to teach with him, said, control is like putting your boot on it. Okay, you've put your boot on it. You've done something more than anybody else has done, and that's why you've got a right that's enforceable against third parties, and that's also to some extent why that person gets priority over a security right perfected by registration in many reformed systems. So I think it's a bit more than just publicity. Although I agree with Manuel Alba that publicity should be a part of it. And in fact, it's one of the reasons why legal control always seems to me to be a problem, because it doesn't necessarily give publicity. So it's a very interesting idea. Thank you very much.
Thank you very much for this reaction, Louise. Also, probably the annotation would go against the factual control in the sense that it becomes something more legal in terms of how and why can you annotate on the digital asset, a part of all the other aspects. I would like now maybe to leave a little bit the issue of control in having the time in mind and come back to one of these various conflicts. As mentioned previously, the rules are there also to try to deal with the conflict between the real world and digital world issues. But Matthias Lehmann mentioned the interesting conflict in time, prior potior iure, prior tempore potior iure. How do you implement the succession in time? Is the first legally binding the more effective one, or the first legally concluded agreement the more effective one? And that has a direct impact, of course, on the applicable law, on the choice of law rule. And I was wondering whether Phoebus, you wanted to react to this idea, either to this or to the other as a first step, maybe, or whether the ELI principles give a perfect answer to that.
I mean, this is not a question to which the ELI principles give an answer, well, not an explicit one. But I would argue that the silence of the principles on the issue of priority, which is of course a very real issue, is intended to convey the message that there is when you have, let's say, more than one security interest established over the same digital asset, then the one that was concluded first in time is the one that, let's say, is the decisive one. Now, I don't recall that at any point in time when we're drafting the principles, we very explicitly addressed our minds to the question of a potential conflict between our proposed conflict of rules. And it could be that this was well, this is something that we should have, let's say, more explicitly reflected upon and addressed. But I would argue that the silence of the principles on this issue is probably to be taken as an indication that we were thinking in terms of priority in time, as opposed to in terms of conflicting validity of different security interests over the same digital asset.
Thank you very much, Phoebus, on that. I was just wondering whether the fact that you distinguished the perfection from the conclusion also in two different principles might be a hint on the impact or on the importance of conclusion as the important factor here. But this is just a thought that I throw in. Maybe we could continue with some questions. There are many questions on enforcing security rights, but if I understand correctly, both the Unidroid and the ELI are still working on the question of enforcing at least digital assets and so on, but maybe on enforcing security rights. Phoebus, do you want to say something specifically on that? Because there were several questions saying, what shall we do now? It's nice to have security rights, but if you cannot enforce them, then what for? And so probably the group had some thoughts about it.
Yeah, well, we do devote one principle to the question of the enforcement of security interests in digital assets. And what we do in our what we did in our work is to provide for extrajudicial enforcement, arguably subject to restrictions that might derive from the applicable insolvency law, if there is such a scenario at play. Obviously, there's an interest in the orderly carrying out of insolvency proceedings, and judicial enforcement, extrajudicial enforcement, might interfere with that. And in another one of the principles that we propose, we suggest that the extrajudicial exercise of a secure creditor's rights would be subject to an overarching obligation to exercise those rights in good faith. So we don't, in the principles, expressly provide for recourse to a court or another judicial instance to resolve a dispute that might arise in relation to the extrajudicial exercise of a secure creditor's post-default rights. But this is, let's say, roughly the approach we take, favoring extra judicial enforcement within the boundaries of the applicable law.
Thank you very much. Yeah, indeed, that's principle 5, right? And you say also explicitly in principle 5.1 that a recourse to the court is possible when it's possible under the applicable law, of course. But then at this right now, at this stage, it might be also important indeed to have extra court enforcement as to this. Time is going forward, so maybe I would get to a next point, which is the one that Robert Reiner Schulter asked at the beginning, wondering whether it would be convenient to harmonize digital assets at the EU level and have something like a overall arching regulation, because you mentioned, or both of you, in fact, the issue about definition. Phoebus said, well, this is, of course, a tricky part. Matthias Lehmann said, yeah, but what social media are captured also by these ELI principles. And Louis Gallifer said, but the definition was central in the sense that we wanted control to be part of the definition of digital asset. And of course, the question is, if we expect to have usable security rights on digital assets, maybe we would have more hard law. Or what is your position on that? And maybe we could have all three of you getting to that point. And I would give the floor first, maybe to Phoebus, and then and maybe then Matthias and Louise in the range you spoke.
Yeah, I mean, I'll be very brief. In an ideal world, indeed, we would aim for a harmonized regime to govern the rights attributable to, if that's the right term to use, to a digital asset. But I would imagine that this is either extremely difficult to achieve or downright impossible, because of course one would need to go down the path of harmonization of the law of property and how different national legal systems treat rights in intangibles. And I think we're very far from, but arguably, yes, if that could be done, that would clearly be ideal. It would also pave the way towards a harmonized approach to creating security interests over digital assets, knowing exactly what their legal nature is.
But would it be, Phoebus, if I may just react, would it be possible to say that this is exactly the reason why the focus was more on conflict of law rules than substantive law rules? Because despite not having a fully harmonized law on property, it might be difficult to come with substantive rules.
Correct, indeed.
Okay. Thank you very much. Matthias Lehmann, please.
Yeah, if I may first come back to this question of enforcement, because I think that was really
sure, of course.
Just one brief comment on that. I think the advantage of the blockchain is precisely that you can do this kind of automatic enforcement, right? By a smart contract, or in the case of staking that I mentioned, you stake your digital assets, and they are used in these proof of stake models for validation purposes, and you hand over basically control to the network. And if your stake is abused for kind of abusive validations, then you lose the stake automatically through technology. So I think we don't need anybody to enforce this, right? Of course, there are these questions where a court wants to enforce something on the blockchain, but for most of the collateral rights that we talk about, security rights on the blockchain, this will be done automatically. The enforcement will be done automatically, and that's precisely the advantage of this technology. Now, coming to the question of harmonization of property law, we know, of course, that under EU primary law, property law is an area that is outside of the competences of the Union. I'm personally not one of those who interprets this too widely. I think we can, for instance, do conflict of laws rules on property without violating the property order. And I would even think that we could have some substantive harmonization on property law issues regarding digital assets, because I don't think that would not expropriate somebody in a member state, because that is what it was basically about, why this rule has been introduced. We didn't want to have the Union the ability to expropriate people in member states and touch on in this sense on the property law. But I would think personally that some substantive harmonization would not necessarily be excluded, but I may be wrong here. I'm not an EU primary law expert. What I think, though, is it would not be sufficient. It would not be sufficient even on the EU level, because this is a worldwide network. And that's why I think Unidroid is really the right place if you look for harmonization of private law to go for, because we need substantive law harmonization on a worldwide level, on a global level, and that the EU is just not sufficient.
Thank you very much. And if I can just react on what you've said, of course, there is a risk not of expropriation, but when you have a conflict between the real world security and the digital world security, and if you decide that the digital world security will preempt over the real world, then it might be an issue, of course, right? Thank you very much. Louise Gallifer.
Thank you. Well, I'll just say something about harmonization. I'm very flattered that you think I can say anything about the EU these days, but sadly, I think I'll pick up what Matthias says and talk about the world, because I can speak for the world, if not for the EU, perhaps, from Unidroid's point of view. And I mean, that is really what explains the architecture of the principles. But what we've tried to do is say, these are the principles on which we think there should be harmonization. There should be these are international standards, if you like, and that's why it's not comprehensive, because you couldn't possibly harmonize the law comprehensively for the whole world. You just couldn't do it, because it would cut into so many different variations within national boundaries. Whereas if you just say that there are a few areas that we think are international standards that everyone should have in their law: innocent acquisition rule, perfection by control, digital assets can be the subject of proprietary rights and security rights, and one or two others, then it is possible to harmonize perhaps in those ways. The other thing I should say, in case I get the wrong impression, is that even at, for example, the innocent acquisition rule, we don't sort of say it goes like this. We say there's got to be an innocent acquisition rule. This is what an innocent acquisition rule means, but states could base an innocent acquisition rule on their own good faith purchase rules. So we're not saying that there would have to be massive detailed harmonization. We're saying there should be a rule with states having some flexibility. And the same is true of the control, perfection by control, if I can call it that. Again, there's a certain amount of variation. So this is not, even within where we suggest there should be harmonization, there are some variations that could operate locally. And of course, the private law justification for the what we suggest, such as, for example, just to talk about custody for 1 second, the fact that the assets held on custody don't form part of the custodian's assets on insolvency, that could be put into play, taking account of the legal culture of any particular state. Thank you.
Thank you very much. We are getting to the end of the time allotted, including on my European watch. But I don't know, Fabius, as a co-drafter, if you want to add something, kind of last word, you're welcome to do so.
Yeah, I mean, I would just like to, I mean, listening to Matthias's intervention, I was wondering if he might not have been, let's say, a fly on the wall of the digital rooms in which we were meeting, because I think he has a good feel in terms of the difficulties that we encountered, and I think all the points that he raised are very valid. I even believe he identified an error in the draft that we may want to ex post correct. I would just want to focus on one point that Matthias made, and this is that this was probably one of the most difficult exercises I've ever been involved in my, let's say, modest academic capacity. I hope that the principles will at least provide some form of basic guidance for the work of others who will, let's say, come and perfect what we have done. I think we're conscious that ours is only an effort to scratch the surface of the issue. I think it's a fair effort, but I think we are conscious as, let's say, drafters that it was a very demanding exercise, and I'm sure that if we, let's say, could have continued our work on it, we would have found ourselves dealing with it in perpetuity. Such being the challenge that we came up against trying to draft these principles. And I must also say that, and I'm sure I'm speaking also on behalf of my co-authors, that we had the benefit of a conference back in December, I believe, where Louise Gallifer was also present, and we found, let's say, her intervention quite reassuring, because it was one of the most solid indications to date that we were not too far off the mark. And of course, knowing that Matthias would assess our work was both a source of concern and a source of inspiration. And I think I can say this without any, let's say, shadow of exaggeration, because this was difficult work and we could use all the help that we could get. And I think we got quite a bit of help. And we are very grateful for that. And I would just, let's say, encourage those who attended the discussion today, if they haven't yet done so, to read and reread the principles. They are likely to discover, points that might call for further reflection. And then these points, perhaps they can fill into ongoing discussions on how to tackle this rather serious real-world issue that we are faced with here.
Thank you very much, Fabius, for these final words. I have to say, we need now to come to an end. And since your words were so beautiful, I wouldn't dare to add much to that, apart from saying that I found this discussion today and these presentations very, very useful also to understand, as you said, the difficulty, but also the importance of the work that has been done, and that these ELI principles on the use of digital assets as security will certainly be an important footmark in order to as you said, continue to reflect, of course, on that, and have some soft law getting harder and harder, maybe in the larger community, being on EU level or in international level, because I agree, of course, I mean, the digital world is without limits in a way, and that's important. It is my pleasure and my duty also to thank all of you, all the panelists first, of course, Fabrice and Athanasiou, but also Luis Gallifer and Matthias Lehmann for the time they took to participate to this fascinating panel, but also many, many thanks, of course, to the other co-drafters and everyone that worked within the ELI to help these ELI principles on the use of digital assets as security to become something that is really valuable. Thank you also to all people attending this webinar, and those of you who asked questions. I hope we were able to put some light, some understanding to your questions as well. And I look forward, of course, to meeting you again in further ELI webinars, the next one being tomorrow evening for those who are interested in consumption and other aspects. Thank you very much to all of you, and have a wonderful evening. Bye-bye. Thank you.